afternoon, everybody. It's Martha. Can you all hear me okay?
Yes.
Yes.
Good. Glad to hear that. So we're going to go ahead and begin. Thank you for all you attendees. We have about 30 right now, which I know includes some conference room full of agents and managers. I appreciate that. I also see we've got some OAs on the line, which I appreciate immensely when OAs have the time to join us. And so we're going to go ahead and begin. If you want to ask any questions, because we are in a few minutes going to mute you all, and so I will not be able to hear you. So, but if you do want to ask a question, we will have a Q&A at the end of the period. But if in the meantime you want to ask a question, you will see a little on your the right-hand side of your screen, a little hand. If you click that, you will be able to ask a question, or you can go down to the very bottom and send me an email that just comes to me, essentially, and I can respond to your question if it can't wait until the very end. Please do not put me on hold. If you do, that brings up the hold music, and it's very disruptive to everybody. So if you need to leave your desk for whatever reason, again, you are on mute, but just put the phone down and then come back, or you can actually hang up and then call in again if necessary. So we are going to begin. Today is I'm going to do the pre-possession addendum and the post-possession addendum, because the pre and post addendum are very similar in a lot of the language, so we can do them, I think, easily back to back. And one of the things I do want to point out, though, on both pre and post, excuse me, and this question has come up. Again, we're going to do pre-possession, post-possession, and I'm going to do them together because they're pretty similar. And but one of the questions that has come up recently over and over again, pre-possession, post-possession should only be used for like 1 to maybe 5 days, no more than, I would say, like 7 days. If any longer, especially on a post-possession situation, usually pre-possession only is a few days, but post-possession could be a lot longer if a seller is waiting to close escrow on their new house, or the builder is going to finish building the house, whatever the case is, and we could be looking at 30 days or more. So again, anytime if it's going to be over 5 or 7 days, a lease agreement should be used, not the post-possession or pre-possession forms. There's a lot more meat to those forms. My only concern with pre-possession, and normally you wouldn't have longer than a few days anyway in pre-possession, as I mentioned, is the pre-possession form. As you can see on the form itself, the addendum, the bold in the very first paragraph, it says, per statute of the Arizona Residential Landlord and Tenant Act, this addendum does not create a landlord-tenant relationship. So my concern is, if you're using a lease, do you have a conflict there? But again, you're going to see longer post-possession than you're going to see longer pre-possession. So if it is going to be longer than for a post-possession, then you would use a lease agreement, because it's a lot meatier of a form. More things can go wrong the longer the seller's in the property, et cetera, et cetera. So again, on a pre-possession, there is actually an exemption to the Landlord-Tenant Act, which is that particular statute that's in bold there. And essentially it says, occupancy under a contract of sale of a dwelling unit or the property of which it is part, if the occupant is the purchaser or a person who succeeds to his interest, that is an exemption from Landlord-Tenant Act. So essentially, the purchaser of a property under a pre-possession does not create a landlord-tenant relationship. So just so you know that. So in the first paragraph, we have the occupancy period and compensation. So essentially it says, upon execution of this addendum by the party, seller hereby grants buyer permission to take possession of said premises on such and such date. Prior to the possession date, buyer shall pay seller as compensation for the use of said premises so much per day for so many days from the date of possession up through the date prior to the close of escrow, for a total payment of blank. Now, sometimes sellers, on a pre-possession, or even buyers on a post-possession say, hey, if it's only going to be a few days, I'm not going to charge anything. To me, that's pretty foolish, and they'll even say the same thing about a security deposit, because as we know, accidents do happen. Although in a pre-possession situation, the buyer doesn't legally own the property, they do have equitable title to the property. They just don't have legal title to the property. And if anything goes wrong, the seller has no monetary deposits or anything to help cover whatever goes wrong. So not having any payments back and forth or any security deposit, again, it's not required, but as far as I'm concerned, it's foolish that the, quote, tenant wouldn't pay something to be in the property. So all payments shall be payable to either to the seller or blank. None of the said payments, none of the sums paid under this agreement will be applied towards the purchase price, and all terms and conditions of this addendum shall remain in effect until buyer closes escrow or surrenders the premises to seller. Obviously, there's a lot of potential problems with pre-possession or post-possession, but normally it's on pre-possession, especially if something happens where either the seller can't close or doesn't close, or the buyer can't close or doesn't close. So the form goes on to say, if buyer fails to close escrow by the agreed-upon date, buyer agrees to pay blank per day beginning blank for possession of premises until buyer closes escrow or vacates the premises. Said payment to be paid directly to the seller, and if buyer fails to close escrow, see, the first one is if they fail to close escrow by that certain date, they will, in other words, we're past the close of escrow date, but they're still trying to get the deal together. Then it goes on to say, if buyer fails to close escrow, buyer agrees to surrender the premises to the seller within blank days. Make sure it's 1, 2 days maybe at the most, maybe 3 days. Nothing more than that. Sometimes I see 30 days on something like this, or like 30 days on the lease purchase addendum where they talks about if there's a default. Every day, essentially, that the buyer is in the premises and hasn't closed escrow or may not close escrow, they're essentially in there free. So you got to be, and plus they could damage the property. Who knows what they could do? So you don't want to make those the number of days that they're in there after the close of escrow more than enough days just for them to move out. It goes on to say, if seller fails to close escrow, buyer may pursue legal remedies prescribed by law against the seller. Okay, now you have a seller who won't close. However, buyer agrees to vacate the premises within blank days. Those 2 blank days should match after the scheduled close of escrow, and if buyer does not vacate the premises within the time period specified herein, then seller may immediately file an action in court for recovery of the premises without the necessity of any prior or additional notice. Per the Landlord-Tenant Act, if there's a breach or potential breach and the tenant's still in the property, that the sellers, before the seller can take any action to evict them, they have to give them like a 5-day notice, et cetera, et cetera. Since this isn't covered under the Landlord-Tenant Act, there's no necessity for any additional notice. But again, so if you have a situation where the seller breaches the contract for sale, the buyer can pursue their legal remedies against the seller for the breach of the contract. But if the buyer's in the premises and won't move out, then the seller can file an eviction action against the buyer. So I hope you can see the difference between a breach of the contract and then a breach of the pre-possession. Next section is the security deposit. And again, as I mentioned, the buyer shall deposit blank into the escrow account, because again, this is prior to a close of escrow, so there is an open escrow account, okay, at blank title company. Again, it's not required that they make any type of security deposit, but they certainly should. Because I'm going to say as a damage and security deposit, at close of escrow, this money is to be applied towards buyer's down payment and or closing costs. So if they're going to deposit some money, which is a security deposit, during the length of the pre-possession, that money now can go towards the close of escrow and their closing costs, because now they are going to close. If escrow fails to close and buyer surrenders premises back to seller in an uncleaned or damaged condition, not acceptable to seller, seller may, at seller's option, retain all or a portion of the security deposit, and seller may hold buyer liable for any additional charges and obligations incurred by seller or caused to be incurred by seller that arose out of buyer's use and occupancy under the terms of this addendum. In other words, if the security deposit doesn't cover the amount of damages that the buyer has done to the property, then the seller can still hold the buyer liable for those extra or additional charges. Seller shall return any unused portion of said deposit to buyer within 14 business days after buyer vacates the premises with an itemization of any monies reasonably withheld. This is essentially, the verbiage is essentially taken out of the Landlord-Tenant Act. When any tenant vacates, the landlord must return the security deposit to the tenant within 14 business days, and if it's any less than the full amount, then they have an itemization of any monies that either an estimate or actual invoices of work that needed to be completed that was essentially the tenant's fault or responsibility. Number 3, use of premises. Buyer shall use the premises as a personal residence only. Buyer agrees to comply with applicable laws, ordinances, regulations, CC&Rs, and homeowners association rules and regulations concerning the premises. Also remember that prepossession doesn't necessarily have to mean physical prepossession. If you have a situation where a buyer says, well, gee, I just want to store some boxes in the garage. I'm not going to move in. I just want to store some boxes in the garage prior to close of escrow. That is prepossession. Or if the buyer says, hey, I want to have a contractor start working on the home prior to close of escrow, which would be really foolish for a seller to allow that, but again, that would be considered prepossession. If the buyer says something like, I want to park my boat in the driveway, again, prepossession. Buyer says, I just want to get in and put in contact paper in the kitchen cabinets. That is prepossession. So it doesn't necessarily have to be physical prepossession in order to make sure that there is some prepossession addendum completed. Utilities and services. Buyer shall have all utilities and services placed in buyer's name and shall pay all applicable charges and costs during the term of this addendum. And number 5, condition of the premises. This is really important because remember, this is going to be completed. This prepossession addendum is going to be completed. Could be at the execution of the purchase contract, but it's going to be completed sometime prior to the close of escrow. So, where do we stand as far as walkthroughs, sellers agreed upon repairs that they're going to do, but now all of a sudden the buyer's taking responsibility, or taking possession of the property, and he's taking responsibility of the property. Although he doesn't have legal title to the property, he has equitable title to the property. So under a prepossession, again, it's not landlord-tenant, under a prepossession, once that buyer takes possession, it is essentially their property. So they have to understand that once they do take possession, it is now an as-is condition, and during that 3, 4, 5-day prepossession, if anything goes wrong with the house, it's the buyer's responsibility, not the seller's. And if you'll notice anywhere in the purchase contract, it talks about upon possession or close of escrow. Everywhere through the purchase contract, it always says upon possession or close of escrow. So once the buyer takes possession, it is essentially his house because he has equitable title to the property. So number 5, buyer hereby acknowledges the buyer has or will have conducted a final walkthrough, because again, this could be signed prior to that walkthrough. Prior to possession. By taking possession, buyer accepts the premises in its as-is condition, subject to any agreed-upon repairs to be made by seller prior to the close of escrow. So in other words, there might be a few things that the seller hasn't gotten around to doing yet that they agreed to do. Buyer hereby releases seller and brokers from all responsibility and liability regarding the conditions, square footage, or valuation of the premises, and neither seller, buyer, nor broker shall be bound by any understanding, agreement, or promise not contained in the contract and or this addendum. So it's one of our disclaimer clauses that we have all over the place in the purchase contract and a lot of these addenda, et cetera. So again, when buyer takes possession, if the air conditioning conks out the day after possession, but still prior to the close of escrow, and they need a whole new air conditioning unit, it is the buyer's responsibility, not the seller's at that point. Really, 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 really important paragraph for the buyer to understand that. Okay, next page as soon as I can get my mouse to work again. Technical difficulty. Okay, hold harmless. Buyer shall hold the seller and all real estate brokers and agents harmless, et cetera, et cetera, et cetera. Again, it's one of our exculpatory clauses that we love to put in everywhere. Seller acknowledges the seller has not relied on any recommendations or representations made by any agent or brokers concerning buyer or the ability of buyer to secure financing, et cetera, et cetera. So it's just basically our general hold harmless clause that we have everywhere. Contingency removal, extremely important. All contingencies contained in the contract shall be satisfied or deemed having been waived on or before the date of possession, notwithstanding to any agreed-upon repairs to be made by seller prior to the close of escrow. What does that mean? Okay, they take prepossession 4 days, let's say, prior to close of escrow, and all of a sudden, 2 days prior to close of escrow, buyer can't get their loan, okay, or their loan docs aren't there, or there's whatever the problem is, okay? They have now waived their financing contingency by signing this post or prepossession addendum and taking possession. As soon as they've taken possession, they have waived all their contingencies, including the financing contingency. Okay, it's very clear, but again, we have to make sure that buyers understand this, that if they, for whatever reason, fail to close escrow, they will probably lose their earnest money under the terms of the addendum. So please keep that in mind for any buyers that you represent, or sellers for that matter. Insurance, probably the one thing that buyers and sellers forget under pre- and post-possession. Buyer shall secure and maintain insurance for personal property and public liability on the premises during the term of this addendum, naming seller as a co-insured. Seller shall secure and maintain adequate hazard insurance to cover the change in occupancy status of the premises. Normally, the occupant or the quote tenant doesn't get any type of insurance on their personal property. Since they are considered a quote tenant, then they would have to get renter's insurance, because if during that short period of time there's a fire, there's a burglary, whatever the case is, and the buyer's personal property is damaged, they will not be covered under the seller's current homeowner's insurance policy, which is still on the property until the close of escrow. Okay, so it's really important that that buyer, it's going to be dollars essentially for that short period of time, but they better get renter's insurance for for those few days of prepossession. The seller should call their insurance company and make sure, because now there's a change in occupancy, that they won't automatically cancel that hazard insurance policy or the homeowner's insurance policy. Usually insurance companies won't, because it's only for a few days. They understand the situation, but they want to make doubly sure that they still do have adequate hazard insurance in place in case, again, if there's a fire or a flood or whatever the case is, that they are covered under their homeowner's insurance policy. Maintenance and repairs from the date of possession, buyer shall maintain and or repair the premises subject to any agreed upon repairs to be made by seller prior to close of escrow. Again, maybe there's some outstanding repairs that seller had agreed to make, or that the property upon possession wasn't in the same condition as it was on the execution of the contract date. So the seller would be responsible for those. And if the seller refuses to make any of those repairs, just as a sidebar, then the buyer can still close escrow, or or file. Issue a cure notice, a 3-day cure notice. The seller doesn't comply, even though it might be now past close of escrow. The seller doesn't comply to the agreed upon repairs or the warranted items, then the buyer can still take their legal remedies after the close of escrow, whether it's small claims court, whether it's per the contract mediation, but they do still have legal remedies, even though it's after the close of escrow. If the seller was issued a cure, because again, you can't have a breach without a failed or unfulfilled cure notice, and at that point, if the seller has not cured the issue, then the buyer can take their legal pursue their legal remedies per the purchase contract. So we have the heating, cooling, mechanical, plumbing, electrical systems, including the swimming pool and or spa motor, filter systems, cleaning systems, and heaters, if any, freestanding ovens, appliances. Again, that's right out of the seller warranty section of the purchase contract, word for word. But we've added to keep the roof watertight and to maintain the grounds during the term of this addendum. So if there is a roof leak, it would be the buyer's responsibility to have that fixed. Now, again, that's added. That's not part of the seller warranties in the purchase contract, but it is still the buyer's responsibility to make sure that they make the repairs. Improvements. Buyer shall not perform any alterations or improvements. This means painting. Any sorts of any type of alteration without the seller's prior written consent. Any improvements or alterations made to the premises by buyer shall become the property of the seller without any compensation to buyer in the event of buyer breach or forfeiture by the buyer. So if they go in and put in new appliances, built-in appliances, or if they do any type of improvement to the property and for some reason then end up not closing escrow, then that becomes the seller's property. Assignment, buyer cannot assign the addendum, cannot sublet. Liens, judgments, and encumbrances, buyer will not allow any liens or judgments to be placed against the premises during the term of this addendum. Seller's right to enter the premises, again, since this isn't under Landlord-Tenant Act, you don't have that 48 hours or that 2-day notice. Seller or seller's authorized representative shall have the right to enter the premises in case of emergency or for the purposes of inspecting, performing agreed-upon repairs or alterations, or to supply agreed-upon service. Except in the case of an emergency, the seller shall enter the premises only during reasonable hours and only after reasonable notice. Again, we don't specifically say the 2-day notice, but we do say it will be reasonable hours and reasonable notice. CC&Rs, buyer shall be responsible for all fines or assessments levied against the seller due to the buyer's actions or conduct that's in violation of the CC&Rs. 15, this addendum contains the entire agreement between seller and buyer with regard to the buyer's possession, et cetera, et cetera. So then you have, obviously, the place for the other terms and conditions. The language right above the signature line, bold, uppercase, this is per ADRE. ADRE requires on pre-possession or post-possession this specific language. Seller and buyer acknowledge that they have been advised to seek appropriate counsel from insurance, legal, tax, and accounting professionals regarding the risks of pre-possession of a property. The reason the ADRE, this is the only time the ADRE requires specific language, is because of all the complaints that they have received regarding pre-possession and post-possession. We have had numerous issues with pre-possession and post-possession over the years. Many times everything goes fine, but when it goes wrong, it goes really wrong. Sellers moving out on a post-possession destroy the property or do a lot of damage to the property, or a seller on a pre-possession now can't close for whatever reason. Buyers moved in, maybe the buyers bought all new furniture for this particular house, and now they have to move out. Obviously they've been damaged. So many pre-possession, post-possession, there's not a problem, but That's why we always say, if there's any way you can get around not doing pre-possession or post-possession, it's better off, because when it does go wrong, it can go really wrong on either pre or post-possession. So any way that seller and buyers can extend the close of escrow or close escrow early to accommodate the other party, that's the better way to do it than with either pre or post-possession. Okay, post-possession. Essentially, the format of the post-possession addendum looks almost identical to the pre-possession. However, in the bold right above the number 1, it says buyer and seller understand that this addendum does create a landlord-tenant relationship because there's been a closing. There's been a closing. Seller's in their post-possession only for a few days. You use this form. Anything longer than a few days, you go straight to a lease agreement signed by landlord, who is now the buyer, and the tenant, who is now the seller. Does create a landlord-tenant relationship, and they hereby acknowledge that a free copy of the Arizona Residential Landlord and Tenant Act is available through the Arizona Secretary of State's office. That's actually, we need to change that. In fact, I noticed preparing for this webinar, it should actually be now the Arizona Department of Housing. Effective January 1st, 2013, the Arizona Secretary of State's office does not have the Landlord-Tenant Act anymore. It's been turned over to the Arizona Department of Housing, and that's where you can find it online, is through the Arizona Department of Housing, not the Arizona Secretary of State's office anymore. So we will be updating this form to make that change. Occupancy period. Upon execution of this addendum by the parties, buyer hereby grant seller permission to retain possession of said premises from the date of close of escrow of the contract to blank. We have had a recent situation where the post-possession addendum was not used, and there was just language put into the purchase contract that said buyer and seller agreed that seller will stay in the property from blank date. Let's say it said March 1st, 2013 through March 6th, 2013. But guess what happened? There was a delay in the close of escrow, and it ended up not closing until, let's say, March 4th. And now all of a sudden you've got an issue with that time frame that the seller was going to take post-possession. So that's why we don't like agents writing things into contracts. We'd actually rather have them use the forms, because again, this addendum starts upon the close of escrow, doesn't start on a firm date, because the firm date may change depending if there is a close of escrow change. So again, we have from the date of close of escrow to blank, 2013. Prior to the close of escrow, seller shall pay buyer as compensation for the use of said premises blank per day for blank days. Normally I tell buyers in a particular situation, hey, you got a mortgage, you're paying per diem on your mortgage. Why don't you at least charge the seller whatever? If you don't feel comfortable with charging them more, at least divide your monthly mortgage payment by 30 days and charge the seller that per diem amount. For total payment of blank, all payments shall be payable to buyer or blank. None of the sums paid under this addendum will be applied towards the purchase price. If seller fails to vacate the premises by the agreed upon date, seller agrees to pay buyer blank per day for each day seller remains in possession of the premises. You might want to have that more than what you had for per diem, because now the seller, that could be putting the buyer in a precarious situation. Buyer's, outside with their moving van in the driveway, and there the seller is. So you might want to put it, $50 or $100 or $300 a day, whatever the case is. If necessary, buyer may pursue legal remedies prescribed by law in order to obtain possession of the premises under the Arizona Residential Landlord-Tenant Act. Again, post-possession is covered under the Landlord-Tenant Act, so they could start the eviction proceedings, but again, they'd have to give the proper notice, et cetera, et cetera. At that point, we would suggest that they get an attorney to assist them in the eviction process. Again, here we have the security deposit. It can be held by the title company. Some title companies will, some title companies may not do this, because again, it's post-possession, not pre-possession. And since there's already a closing, they may not want to be involved in this. As damage and security deposit, seller agrees to surrender possession of the premises to buyer in substantially the same condition as at close of escrow. If seller surrenders possession of the premises in an unclean or damaged condition, not acceptable to buyer, buyer may at buyer's option retain all or a portion of the security deposit, just like we talked about post-possession. They have 14 business days to return that security deposit, and if it's not the full amount, then there's an itemization of monies reasonably withheld, either actual invoices of work that needed to be done, or estimates of what would cost to have that work done that was deducted from the security deposit. Use of the premises, seller should use it only as a personal residence. Again, seller complies with all CC&R's rules, HOAs, et cetera, et cetera. Again, this is very similar to the pre-possession addendum. Seller will continue to have the utilities and services in their name, and they'll pay all charges. Maintenance, seller shall maintain the premises so that, again, all the heating, cooling, mechanical, plumbing, electrical system, et cetera, again, right out of the purchase contract, are in normal working conditions and keep the water or the roof watertight and to maintain the grounds during the term of this addendum. Repairs. Seller shall be responsible for the first $75 of any repair. Why did we pick $75? Because hopefully in a post-possession situation, there is a home warranty on the property. If there is a home warranty on the property, hopefully whatever repair needs to be done would be covered under that home warranty. And again, hopefully it's Coldwell Banker Home Protection Plan. And $75 is now the current service fee for Coldwell Banker Home Protection Plan or American Home Shield. So we just recently did revise that because of their change in their service fees that is effective March 1st. Then we do say or any home warranty deductible, because maybe that's higher, maybe it's lower than some others. Whichever is less, buyer shall be responsible for any amount that exceeds $75 because, again, the buyer is the landlord. If any damage is due to seller's negligence, seller will be fully responsible for said damage. Hold harmless, there's our hold harmless clause that we love to put in there. Insurance, again, we bring it to the seller's attention because now the seller in post-possession is the tenant. They shall secure and maintain insurance for personal property and public liability on the premises because being the tenant, they are going to need renter's insurance because any of their personal property that gets damaged while they're in a post-possession situation is not covered under the buyer's new homeowner's insurance or hazard insurance policy. The seller's insurance policy was canceled upon the close of escrow. They would also want the insurance policy of the sellers to name the buyers co-insured, and buyers shall secure and maintain adequate hazard insurance to cover the change in occupancy status of the premises. Pardon me. Usually, again, buyers, homeowners insurance, if it's only for a few days, understand it's just a very brief post-possession by the seller, and they won't make them, change their insurance policy to non-owner occupant or investment property or whatever the case is for only those few days. But the buyer should contact their homeowner's insurance just to make sure that is the case. Improvements. Seller shall not perform any alterations or improvements to the premises in any way without buyer's prior written consent. Both forms say written consent for obvious reasons. Want to make sure that there is a way to prove that there was consent given, and it's just not a verbal he said, she said if it ends up in a litigation situation. Any improvements or alterations made to the premises by seller shall become the property of buyers without any compensation to the seller. So I don't know why the seller would make any improvements, in a post-possession situation, but if they do, then obviously those improvements then become the property of the buyer. Liens, judgments, encumbrances, the seller shall not allow any of these to be placed upon the property during the term of this addendum, can't be assigned. Buyer's right to enter the premises, again, now it's Landlord-Tenant Act, So buyer or buyer's authorized representative have the right to enter the premises in case of emergency or for the purposes of inspection, performing necessary repairs or alterations, or to supply necessary agreed-upon service. Except in the case of an emergency, buyer shall enter the premises only during reasonable hours and only after 2 days' notice per Arizona Landlord-Tenant Act. Seller shall deliver to buyer a full set of keys and, if applicable, any alarm codes to the premises upon close of escrow. CC&Rs, seller, again, agrees to be responsible to pay for any fines. This is the entire agreement. Any other terms and conditions would be written in there. Here's the ADRE language again. Seller and buyer acknowledges they have been advised to seek appropriate counsel from insurance, legal, tax, and accounting professionals regarding the risks of post-possession of a property. Usually the risk is on the buyer in this particular situation, because we all know that once you don't have pride of ownership, and again in a post-possession, it's already closed escrow, seller's in there as a tenant, they're moving out, they may not care about how many times they get a leg of a couch through the wall as they're moving out, or if they spill something on the carpet. Or we had one situation where all the seller's relatives came to stay at the house during the post-possession period of time to assist the sellers to move, and we're talking 10 people with their dogs, their cats, everything. So needless to say, even though it was a short period of time, by the time they all moved out, the property was not in the same condition as it was prior to the close of escrow, and the buyer actually sued the seller in small claims. So again, many problems can happen in post or pre-possession. Many times nothing happens, but when it goes wrong, it goes real wrong. So just kind of recap, the most important things to take away from this webinar is, number one, only use pre-possession, only use post-possession for a few days, especially in a post-possession situation. Anything longer than that, especially in a post-possession situation, the buyer and seller should complete a lease agreement. Always point out to the landlord, whoever that may be, the importance of a security deposit, and they should probably charge the quote tenant a per diem amount that they're in the property, and always point out to both parties the importance of having insurance, whether it's personal insurance, renter's insurance, or obviously the hazard insurance, and not any issues with the quote landlord's insurance company when they have not yet taken possession of the property. So that's about it. We are going to now unmute you all, so if you have any questions, you are certainly welcome at this point to ask any questions.
The leader has unmuted your line.
Anybody have any questions? Oh, come on, I know there's at least one out there.
Is that for questions? Yeah.
Martha, can you hear me?
I can.
That's Jim Callery.
Hi, Mr. Callery.
Hello. So I have actually been in this position before. So we have in there that the seller will pay $50 a day for the amount of time that it takes them to move out of the property. How do we collect that?
Well, usually it's paid up front.
Well, I think that's good. I like that plan.
Yeah, it says in the forms, it says prior to the possession date, buyer shall, this isn't pre-possession, or obviously be the same in post-possession. Prior to the possession date, buyer shall pay seller as compensation, blah, blah, blah. So get the money up front, because you don't want to end up chasing it, later.
Well, I'm talking about the seller that is not moving out, so it's a post-possession.
So post-possession? Okay, post-possession.
Yeah, and the example you brought up, which is real. The buyers are sitting in the driveway with a U-Haul full of stuff they want to move in today, and the sellers have agreed that they would be moving out on this day, and that they'll pay $50 a day for each day that they haven't moved out, but they haven't had time to pack up, so it's going to take them another 4 days to move out, and the buyers are sitting in the driveway.
Right. You're right, Jim, and that does happen. The post-possession addendum does say, again, there's going to be potentially two different amounts put in there. if the first one says prior to the close of escrow, seller shall pay buyer as compensation for the use of the said property blank amount of money. Okay, now in your particular situation, the seller fails to move out, the seller agrees to pay buyer X amount, okay? If they don't pay it or if they don't move, then obviously the buyer's recourse is to go through the eviction process, and if they didn't pay the money that they contractually agreed to, they could take them to small claims as well. Plus, they would potentially have damages because now they have to store their furniture that was in the moving truck or whatever the case is.
Yeah, nobody wanted to ask a question, so I felt like that was a good question to ask. But
Yep.
I actually did have that happen to me, and the seller said, so sue me. I'm not paying it.
Yep, I mean, that does happen. And the other thing that happens sometimes is that sellers become emotionally, and I know how crazy this sounds, but they become so emotionally tied to that house they've lived in for 20 years, and all of a sudden now reality has hit them that it's no longer their house, and they just basically put their heels in their sand and they say, I'm not moving. You know, I just can't bring myself to move. So again, that's a landlord-tenant situation. But even if the seller does not move and the buyer has to go through the whole eviction process, it could take up to 30 days. And obviously, every day that seller's in the house, the buyer could be assessing more damages.
All right, thank you. It's somebody else's turn.
Well, can you hear me?
I can.
This is Linda Lightfoot.
Hi, Linda.
Probably about 20 years ago, this is a story about this exact thing. About 20 years ago, I had an agent, and he was relatively a new agent, and so he had gotten a listing over in the Paradise Valley area, and he'd sold it, and he'd sold it himself. So he goes to, it gets closed, the buyer's just a wonderful buyer. The seller is a nice lady, but as you said, emotional. There are a lot of emotions going on with this house. So he goes to, it closes. He goes the next day with the buyer to, you know, he's going to get the keys from the seller because the seller was going to move out that day. And they go there. Nothing is packed.
Mm-hmm.
Not even, you know, not even the utensils. Nothing's packed. So this young agent just has got the deer in the headlights. So finally, he was very creative. He went and hired one of his fellow agents' 18-year-old son, and hired his truck. And he went, I think, to Kmart and bought 50 laundry baskets. And he and this young kid went back to the house and helped the seller move out.
Oh, that was nice.
I think they finished about 12 midnight.
Wow. Wow.
But he had both sides of the transaction.
So
I thought that was
worth it to him. Yeah.
I thought it was pretty creative.
It was very creative. I thought you were going to say that he went to the house and moved the seller out. You know, the seller comes home and all of a sudden all her stuff's moved out.
Oh no. The seller was he was helping the seller, but I mean, I thought that's pretty creative. And
yeah,
everybody,
no, exactly.
you know, the buyer was understanding. So things do have a positive ending, but yeah, I mean, he went there and he said, I couldn't believe my eyes.
Yeah, I can imagine. We actually had a situation where the seller inherited the property. The seller was like this young kid. He was like 18 years old, inherited this property because his mother had passed away recently. He had never lived in the property. The property was still completely filled with mom's furniture, personal possessions, her china, her silverware, everything.
Oh,
and essentially, it closes escrow, and he disappears. We'd think he had some drug issues or something, and he just took the proceeds and just disappeared. Now what do? Now we have a full house full of furniture, and here come the buyers with their moving truck, and of course they can't move in. And so what do? Well, you know, essentially, landlord-tenant says, well, you can move the stuff out. You have to send notice to the seller. So you don't know where the seller kit is. So what you should do is have a letter sent to the property address, and hopefully there's some type of forwarding address for mail, and just say, hey, if you don't pick up your possessions within X amount of time, we're going to, sell them or whatever the case is, and that is basically the law, and that's what you have to do. You don't have any right to, put them on the curb or, call Salvation Army or any of that until you've given proper notice to the tenant. So, to the tenant, which in this case is the seller. So, interesting stuff. Any other questions? Well, I think that's it. So thank you all for attending.